Good afternoon and welcome to today's presentation, Top 10 Ways Health Insurance Companies Avoid Paying Claims and Top 10 Ways to Get Paid. In today's webinar, Mr. Amador will discuss policies, out-of-network claims, relevant documents, UCR, violations, and bad faith. To give you a little background about our presenter, Robert Amador, he has practiced law in Southern California for more than 25 years, most of which have involved health law. His career began at two major law firms in Los Angeles, and he later became in-house counsel as Chief Legal Counsel of Travelers Health Insurance. He then earned the position of General Counsel of Maxicare Health Plans. Since April of 2000, he has been in private practice, specializing in healthcare and civil litigation. Attendees who require a passcode, the word for today is claims. During the Q&A session, we'll ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you're applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. You are also required to complete the survey at the end of the program. Tomorrow morning, we will send out an email with a link to the archive recording of the webinar. The slides can be downloaded from the resource list to the left of your screen. Thank you all for attending today, and Robert, the presentation is now turned over to you.
Yes, thank you everyone for attending and for taking time out of your busy schedules. Again, my name is Robert or Bob Amador, and just one correction, I wasn't the General Counsel of Maxicare, I was a General Counsel. But since 2000, I've been on my own, and I've been in private practice as well as serving as an expert witness on cases, including cases involving reimbursement and claims. One of my big clients, once I went on my own, was DaVita, which is a large renal dialysis company nationwide, and they had hired me and then my partners to pursue collection of various ERISA claims throughout the country against self-insured health plans. And then I became kind of an expert on ERISA. Let me just digress a little bit and talk about the U.S. healthcare system, which of course is very, very vast. As of 2015, the U.S. healthcare national expenditures are supposed to exceed $3.2 trillion. That's with a T. By far the largest healthcare system in the world. Per capita, it's estimated that about $10,000 per year is spent on every single person in America on their health care. So there's obviously a lot going on in the healthcare system. It's going to grow as Obamacare increases and as the population ages. So while this presentation is limited to the private healthcare sector and not to Medicare and Medicaid, many of the same principles do apply as we go through this. Of course, today's presentation could be fit into a half a day or even a full day, and I'm going to try to squeeze it in the 50 or so minutes that we have, allowing for questions as well. Let me just quickly go over the outline here. I'm going to advance the slides so that you can get an idea of where we're going with this. It looks like you don't have the outline itself, so I'm just going to go through it quickly just as an overview so you can see what topics we're going to cover, and then we'll get into the substance. We're going to talk about how health insurance companies use the policy as the main vehicle by which to deny claims. It sounds trite, but many people don't realize that the policy is an operative document and they've got to look at it, and first they've got to obtain it. Many claimants don't even have the policy that they want to take action on. We're also going to talk about out-of-network and UCR. Out-of-network being that the health insurance companies will say the provider is not a network, and as a result, their charges are not covered, or if they are covered, they're excessive because they're not the usual, customary, and reasonable charge. Another key thing they talk about, probably one of the biggest, is they'll say a claim is not medically necessary. They'll also say that they're not going to honor the assignment of benefits. So as you all know, when you go to a healthcare provider, you assign the benefits to that provider. the provider expects to submit a claim and get paid, but in some instances that's not honored, and that causes problems and delays. They also will say that the documentation that was submitted in the claim was incomplete or at least not received, and we'll get into that. It's kind of a document game they play. And if they have acknowledged receipt of the documents, they'll say that the documents do not support treatment, so that'll be number 6 on my list. In some cases, they'll say that the provider, the claims are preempted by ERISA, which I'm sure many of you are familiar with the federal ERISA law. They'll sometimes threaten that there's been some fraud and abuse, threaten to seek an overpayment. They'll also say that the claims that were filed were duplicates, or that they need to be bundled, that they can't be separated out. And then lastly, they'll say that the claims or the appeals, if there are appeals on the claims, are untimely. Those are the top 10 ways that we're going to be discussing that health insurance companies avoid paying claims. Now, for a happier topic, the top 10 ways I believe you can use to get paid are, number 1, relying on the treating doctor. That's very, very important. Number 2, get an agreement up front, if you can, authorizing the care and acknowledging the eligibility of the patient. Number 3, fight the qualifications of the reviewer. So if the health insurance company has a reviewer looking at the claim and saying it's not medically necessary, that's something that can be challenged. Threaten to balance bill the provider, or even have the patient go to the employer and complain that the claim's not being paid. That can provide some pressure on the health insurance company. Threaten breach of fiduciary duty, or at least look into whether, in fact, there is a claim of breach of fiduciary duty. Conflicts of interest. Many times the insurance companies, especially in the self-insured market, will have the same entity paying the claim as making the claim decision. The UCR, that's a big area of dispute. That's the usual and customary and reasonable battle, and that can be fought successfully. Threaten insurance code or ERISA violations. These insurance companies are often regulated unless they're self-insured plans, and they don't like complaints to the regulatory authorities. Request all relevant documents. That's a very big tool that should be used when fighting back. And then lastly is bad faith, to the extent that there can be a bad faith action, which would be outside of ERISA and where there's no contract. That's a very powerful tool as well. So that's where we're headed. And let's get started with the first slide, which is the policy. The policy is the operative document. Again, that is the key for any claim decision. It's an enforceable contract. Unfortunately, nobody reads the contract when they're given the contract, if they are. And when I say policy, I mean anything that's given by the insurance company or the self-insured plan, whether it's evidence of coverage in the case of HMOs, or in the case of self-insured plans, it's called a summary plan description, or just a regular insurance policy. Those are the operative documents, and they've got to be looked at carefully before any dispute is made concerning the payment of a claim. The operative documents will, of course, contain definitions, and the definitions go on and on and on in these documents. I've seen some that go on for 10 pages or more. They're very detailed, and they'll include definitions on medically necessary, experimental claims, and other types of definitions that the insurance companies will use and rely on in denying the claim. The operative document will also contain exclusions. For example, anything that's cosmetic is not going to be covered. Anything that's not authorized in the case of an HMO or a similar plan is going to be excluded. And they'll often have limitations on coverage. For example, yes, the claim will be covered, but they'll only pay maybe $500, or there'll be a fee schedule of some kind that either they impose themselves, or they might refer to a Medicare or a Medicaid fee schedule, and those will cap the amount that's paid on a claim. Furthermore, if there's going to be any kind of appeal of the claim, the policy will spell out administrative remedies, and many of them have binding arbitration provisions as well that are going to be binding on any person claiming a dispute over the payment. The second slide has to do with claims being out of network. This is also a popular one that health insurance companies use. It's primarily used with HMOs and what's called EPOs. EPOs are exclusive provider organizations. They're usually a smaller share of the market, but similar structure. It's usually not the case with a PPO, but certain plans have variations in the way they're structured. HMOs nationwide are about 25% of the market and growing, so this is going to become more of a common denial basis. What the health plan will be saying is unless the claim was emergent or urgent, it has to be approved by a participating provider. And usually there's enough providers so that you can't argue that the coverage of providers was inadequate, and therefore you couldn't get the care in the geographic area where you are. So most of the time that's a winning argument for them, unless you can say that the claim was so urgent that you didn't have time to go to a participating provider. Once the claim is out of network, even if it is covered somehow, then there'll be this battle that we'll talk about more in detail about the usual, customary, and reasonable amount. There's an organization some of you may have heard of called Fair Health. It's a nonprofit organization, and they're the ones that the industry often looks at for a determination of what charges are usual, customary, and reasonable in the marketplace for the particular geographic area and specialty in question. Fair Health apparently has something like 19 billion claims in their database, so it's including medical and dental, and it's therefore a good basis on which to rely for a baseline of what the proper charge could be. But as we'll discuss in a minute, there's a lot of fighting over whether Fair Health's data is accurate. Slide number 3 is, or at least point number 3 is that the service is not medically necessary. This, in my opinion, is probably the single biggest area of dispute, and the one that the health insurance companies rely on most. And the reason they rely on it most is that it's wide open, and they have control over it. It's required in every single policy or EOB or SPA. SPA itself is a single patient agreement, by the way. It's kind of a specialized thing that's done usually with large claims. Well, you get have an agreement up front with the health plan, and that for a single patient. But in any event, the service always has to be medically necessary, and the insurance company is the one that decides whether or not it is medically necessary, and they'll rely on the definition in the document. They'll often say that the treatment is not supported by the diagnosis based on the claim submitted, or that the treatment is not supported by the patient's history, or they'll say that there's a less invasive or more intensive treatment that's appropriate, or one way or another, less or more, that's appropriate, and therefore the one that was used was not going to be paid. This then results in a battle between experts. Usually the expert is the treating physician from the claimant standpoint, and then the insurance company will have a claim reviewer who will be their expert and will make the determination of whether or not the claim is medically necessary or appropriate. what I'd like to do very briefly here is read to you a real definition from a Blue Cross plan that was issued here in Southern California recently to a large group of retired teachers. And it says, medically necessary procedures, supplies, equipment, or services are those that we determine to be appropriate and necessary for the diagnosis or treatment of the medical condition, provided for the diagnosis or direct care and treatment of the medical condition, within standards of good medical practice, within the organized medical community, whatever that means, not primarily for your convenience or for the convenience of your physician or other provider, and the most appropriate procedure, supply, equipment, or service which can be safely provided. Again, this is all within their determination or their reviewer's determination of what is medically necessary and appropriate. In addition, they say that to determine appropriateness, the procedure must meet the following. There must be valid scientific evidence demonstrating that the expected health benefits for the procedure, supply, equipment, or service are clinically significant and produce a greater likelihood of benefit without a disproportionately greater risk of harm or complications for you with the particular medical condition being treated than other possible alternatives. And it goes on and on beyond that. So you can see how huge this hole is and how many legs there are for the insurance company to stand on in denying the claim. The next slide deals with assignment of benefits not honored. This is one that's usually used more in the ERISA context, where it's a self-insured plan, or something similar where there's a non-participating provider. But what happens here is that the assignment is given to the doctor, which is intended to allow the provider to pursue the claim and pursue any appeals to get paid, since they have the knowledge of what was done. The health plans will often dishonor that based on the plan document. And they'll do that for several reasons. One is to try to force the provider to go in-network into the plan and not be an out-of-network provider with no contract. They'll also make it harder to get the claim paid and appealed, because now the patient has to do all the legwork and the provider is out of it. Now, if that is the case, there's usually a delay because the process that's been started by the provider is now reversed and has to be started by the patient. Fortunately, at least under the ERISA regulations, the patient can appoint a representative, which could be the doctor, it could be a lawyer, it could be anybody to represent them in the appeal. And even though most laws do allow assignment generally, sometimes in the actual policy or operative document, the health plans will add an anti-assignment provision in the document, which has been enforced by the courts as a general matter. If the insured is to dispute the claim, the insured has to exhaust the administrative remedies before they can sue or arbitrate the claim. And the administrative remedies are spelled out in detail in the operative document. Those are the what's called the grievance and appeal procedures that are spelled out, like I say, in every policy or every document. And that is the first place that must be looked at if there's going to be a dispute or an appeal of a claim. The next slide has to do with incomplete documentation. This is probably also one of the more favored ways that health insurance companies avoid paying claims. They'll often say the claim was never received, or if it was received, it's missing key documents. And I've seen this game played ad nauseum by some health plans, and they seem to get away with it. Although, as we'll talk about in a minute, there are ways to fight back. And of course, there's this concept of a clean claim in the health insurance business, which simply means that it has to be complete and not missing any relevant information. They'll usually want the history and physical. They'll want an operative report or a post-op report if there was surgery and pathology results and lab tests. So one of the games they play is to say, yes, we've gotten some documents, but not others, and the claim is not clean. Therefore, the clock does not begin to run. And the clock is governed by statute and regulation. It's usually 30 to 45 days, depending on what type of plan you are, which is the time period the health insurance company has to respond to the claim. And then they sometimes will look at the documentation and say they suspect fraud or they suspect abuse, and they will refer the claim to their special investigative unit, which is an SIU, and that's a unit that's set up to investigate fraud and abuse. But if that happens, what this results in is a long delay of the claim payment, and really a different type of dialogue as to whether or not there has been any fraud or abuse. As we'll go through later on, there are some unfair claims settlement practices laws in the states and also under federal law that can be used to fight some of these document games that insurance companies play. Related to incomplete documentation is the notion that the documents do not support the treatment. Again, this is usually done by a medical reviewer within the company who will say that the diagnosis, the ICD-9 or ICD-10 codes, and the procedural codes do not support the medical records. And the reviewer will make a determination. The claimant's entitled to that review and needs to ask for it, as we'll discuss later. And sometimes they'll deny some but pay only those documents that they believe are supported by the medical records. Pay those claims, rather. The next slide has to do with ERISA preemption. Again, that's more an area that comes up with self-insured plans. But any health benefit that is obtained through employment is covered by the ERISA law. And ERISA will preempt any state laws that relate to the employee benefit plan. However, there's what's called an insurance savings provision within ERISA, so that the insurance laws of each state are preserved, they're not preempted. Most of the plans that people get through health benefits that are regulated plans like Blue Cross or Aetna or whatever, those are regulated by both ERISA and the insurance laws, but the insurance laws are usually the ones that govern the state insurance laws. If, however, there is an ERISA preemption, what that means is that all the state procedures and the actual state laws that conflict with the procedures of ERISA are in fact preempted, and that the Department of Insurance regulations do not apply. There are different appeal deadlines. There's often no assignment of benefits, as we discussed. And federal laws would apply, and federal regulations governing ERISA do exist, and they're very helpful. They can be found at 29 CFR 2560.503-1. Again, that's 2560.503-1 for anybody that wants to look at the ERISA regulations governing claims and appeals. And we'll get into those a little more later on because I think they're very helpful in terms of fighting denial of claims. And you should know that ERISA does not apply where there's any kind of a government plan or any kind of a church plan or religious type organization plan or individual plans, nor does it apply to Obamacare, which is basically an individual plan, or where there's any kind of a contract. But short of that, ERISA does apply to any, as I say, any benefit obtained through employment. And if it's a card that the insurance companies want to play, especially if there's an arbitration or a lawsuit, they will invoke this because it limits their damages to just the plan benefit and possibly to attorney's fees if they lose. But there's no bad faith damages, no tort damages of any kind in the event of ERISA preemption. Another thing they do, as I alluded to earlier, is they can threaten fraud and abuse. If they do that, there could be an indefinite delay of the claim because it will be assigned out to a special investigative unit. And they'll also threaten an overpayment. This is where they have been paying and then they suddenly realize that maybe they shouldn't have been paying, or they don't like the fact that they've been paying. There have been cases where the actual health plans do sue the providers or the patients. It's kind of unheard of, but they are out there, and many of them have become more aggressive in recent times. There are cases, however, that say that the burden is on the health plan and not on the healthcare provider, that the health plan should know, what is payable and what's not. And if there has been no fraud or misrepresentation, then in fact the provider does not have to pay back what they've been paid. If there is a threat of fraud and abuse, what they'll often do as well is they will flag future claims. So that means that there'll be an extreme delay or possibly a total non-payment on any future claims from the same healthcare provider. Okay, the next slide has to do with duplication and bundling. This is also a very common way that they avoid paying claims. They'll say that the claims that have been submitted are duplicates of prior claims. That's why it's so important to keep a very accurate record of what's been submitted and when. They'll say that claims, this says are, but it should be bundled and must be filed separately. I'm sorry, it's the other way around. Cannot be filed separately. So, for example, if a surgeon is in the process of doing a surgery and he has to remove some lesions and then do the actual surgery, they'll say that no, you can't just bill separately for the removal of lesions and separately for the surgery. You have to bundle the claim and pay it as one claim, which of course is a smaller amount that's going to be paid. Sometimes they'll say that claims have been upcoded and they will downcode them themselves. So, for example, if a physician it does a checkup and he bills for an extended checkup, say $100, where there's been more time put in, more consultation, the insurance company may say no, that based on our review or based on the history of the patient, really this is just a regular checkup, so we're going to use a different code for that, and we're not going to pay the upcoding that's been done. The next slide is untimeliness. This is not that common a way they avoid paying, but it can involve both the untimeliness of the claim itself, which usually is not the case, or untimeliness of an appeal of a claim, which is more common. All the operative documents will spell out the time that a claimant has to submit both the actual claim itself and the appeal. There are federal and state laws that govern the timeliness of claims and appeals. The policy or the operative document itself will have a deadline for the claims appeals, and it's questionable whether those are enforceable because these contracts are often deemed to be contracts of adhesion. Nobody really reads them, and certainly they're not represented by a lawyer at the time that they're given to the covered person. And then there's an issue of whether there's a statute of limitations that would apply. The statute usually for contract is 4 years. ERISA sometimes has a 6-year statute. So, it's going to be an issue of what law applies or what statute applies. Usually there's enough time to do the actual claim. It's usually about 90 days or more to file the claim itself, unless the person who should have filed the claim is incapacitated or something. And the appeals are usually 180 days from the time of the initial adverse decision. And then after the appeal decision is made, there's another timeline. It's usually 60 days or so. But that's a key area that needs to be looked at whenever there's a dispute and an appeal of a claim. So I think now we're going to turn it over for some initial questions. Is that right, Emily?
Yes, and could all the attendees please type the passcode into the Q&A? Our first question is, what is the nominal dollar value break-even point for challenging carrier denials?
Nominal break-even value for challenging denials? I don't know if there actually is one. If you're talking about the dollar amount of the claim and you're talking about someone hiring counsel, obviously there has to be some significant damages there, and the health plan will often pay the claim directly to the provider and not to counsel or to even the patient. So there has to be an agreement with the provider if there's going to be a contingency fee. But I don't know of an actual statistic on nominal break-even for challenging. I would say my experience is you should look at the larger claims. Only take large claims to appeal. Or what I've done in the past is I've bundled a whole bunch of claims, a whole bunch of smaller claims to get a much larger claim and do it that way. Next question.
Okay, and is Kaiser Health Foundation subject to bad faith for denying a claim or providing service?
I'm sorry, can you repeat it?
Is Kaiser Health Foundation... Sure. Is Kaiser Health Foundation subject to bad faith for denying a claim or providing service?
Yes, they are. If it's what's called a first-party claim, meaning the person suing them is the insured. All Kaiser documents have mandatory binding arbitration, and so that caps the damages. But yes, you should be able to pursue even a tort claim for bad faith against Kaiser, but it would be in an arbitration context. But again, you'd have to be careful that there is none of these other areas. There's no ERISA preemption, and other things that would prevent a bad faith action. But yes, as a general matter, they are subject to it. Next question.
Okay, and how long does someone have to submit a claims dispute?
Well, yeah, I was just alluding to that. Again, number one thing to do, get the policy, even though it may take a while to get it. You have to ask for it from either the patient if they have it, or the health plan itself, and they're legally required to give it to you. Like I say, it's usually around 90 days or so just to submit the claim, and they're pretty flexible on that, or 180 days to appeal it after you've gotten a denial. Those are the general rules. Each state may have their own state laws on it, and then there's the federal regulations that I cited to earlier that govern that.
Okay, and how do insurance companies determine the customary rates or charges in the relevant community? How large is the relevant community in terms of medical providers or geography?
Well, those are very good points because there is no hard and fast rule on it. Number one, you look at the operative document, see if that talks about it, and even if it does, you challenge it. But probably the best place to go is case law, and there's actually quite a bit of case law in this area. when we get to the next part of this webinar, I'm going to actually read you the California law on that very, very point. And then there's a fairly recent case on that point. But at least out here in California, there's been a lot of litigation in that very topic.
Does each code correspond?
Go ahead, I'm sorry.
Sure. Does each code correspond to a specific amount, or is there a range within each code?
The code will just determine the procedure or the disease, and then it'll be up to the health plan what they pay for that. And that's where they have a lot of leeway because, as I say, depending on the type of plan, there could be a fee schedule that they rely on, either their own fee schedule, or they'll say this is subject to the Medicare fee schedule, which is usually the lowest in the country. So that just determines the procedure or the illness and not the actual payment amount.
Okay, those are all the questions we have for now. We will have another break for a Q&A at the end, so please continue with the presentation.
Okay, the next item is, these are the happier topics of the 10 ways to get paid. Rely on your treating doctor, and I've been very successful with that. And the reason is that the treating doctor carries more weight than a reviewer. And what that I mean is that the treating doctor is the person who has a history with the patient, has examined the patient, treated the patient. And in the case of a surgeon, I had a case recently with a surgeon, they actually saw inside the patient's body. So they can very accurately describe what they saw and what was needed from a medical standpoint. And how can a reviewer sitting in an office someplace who's paid for by the insurance company, how can they challenge that? Not to say that it's always a slam dunk, but I've been pretty successful with that. And the treating doctor can provide medical records, of course, and they can also provide a declaration. If it got to an arbitration or litigation, they could be an expert witness. And as I say, they carry a lot of weight. The next item is get an agreement authorizing the care. This is usually where there's a larger claim to be incurred, usually before the claim is about to be incurred. And people don't always have the luxury to do that, but some providers do, and I do represent providers. They will negotiate up front for a larger claim, and they will get the rate put in some writing before it's actually incurred. Even if these are just done by phone, whether the health plan will authorize the treatment by phone up front, document that, and that's sometimes enforceable against the health plan. And when you do get the authorization or the document up front, make sure that they acknowledge that the patient is eligible, because sometimes they will actually challenge the eligibility of the patient after the fact, either based on, maybe there was a divorce and the person shouldn't be a dependent anymore, or the person has actually been dropped off the employer's payroll or something after the fact, and by then it's too late because the healthcare provider's already incurred the time expense of the procedure. The next item is fight the qualifications of the reviewer. By this I mean look who their reviewer is. This is where there's been a challenge regarding medical necessity, and they will say that the treatment of the procedure is not medically necessary or appropriate, and they're supposed to tell you why and what the basis is. You may have to dig that out of them, and we'll get in a minute to the portion that entitles you to get documents. But they will oftentimes just have a nurse challenging a physician. So that should be a loser for them. And I've had arbitrations in which that was the case. Or even if they have a doctor, the doctor has to be of the same specialty as the treating physician in order for them to have a successful challenge on medical necessity. For example, if the client is the provider is a plastic surgeon, it may not be enough for them just to have a general surgeon or a primary care physician to challenge what the plastic surgeon did. So they're going to have to be of the same specialty. Fortunately, there are state and federal laws on this, and if you look at most policies and most plan documents, they will spell out what the procedure is for challenging medical necessity. And then in addition, if there has been an appeal or a grievance filed, they are required to take into consideration any documents that the provider or the patient has given them. So even if they took a position at one point in time, after the grievance or the appeal has been started and more information has been provided, now they have to take all that into consideration and come up with another decision. It may be the same conclusion, but they have to take everything into consideration. The federal law has what's called a full and fair review, which is a very powerful tool that should be used if ERISA applies or the federal regulations apply, where the trustees or the health plan administrators have to provide a full and fair review of all claim denials. And once again, that would include any new evidence or any declarations or other documents provided by the provider or the claimant. The next item has to do with balance billing and putting pressure on the employer. This is more of a nuanced way to get paid. It's kind of putting political pressure on the health plan through the employer and the patient. If the provider is out of network, that means they're able to balance bill the patient. So they can either do that or threaten to do that, and that adds to possible damages in a bad faith case, because now the patient, the insured, is possibly subject to collection. But if the patient goes to the employer and says, we have this health insurance, but it's worthless because they're not paying my bill, and they're putting me into collection, now the employer may want to go to the health plan and say, what are you guys doing? My employees aren't getting their claims paid. Excuse me. Some providers, as I say, if they're not out of network, let's say HMO providers or contracted providers, are not allowed to balance bill their patients. So this political pressure ploy would not serve their purposes. But I've seen this work in the past. Usually, it's for larger employers to put pressure on the health plan to pay. The next item has to do with breach of fiduciary duty. The health care administrators and the trustees of these health plans are fiduciaries, which means that they're expected to follow the plan documents, to act in the best interest of the insured. A fiduciary is the highest standard that the law requires. It's like a trustee. And so if there's going to be an appeal or some kind of litigation, I often invoke that they've breached their fiduciary duty, they haven't acted in the best interest of the patient, they haven't followed the plan documents, and they haven't acted with diligence or with competence. It's not, unfortunately, applicable to just clerical people, but to the extent that higher-ups have been involved, it is a helpful tool. Number 6 on how to get paid, it has to do with invoking a conflict of interest argument. Again, this is a little nuanced too, where the organization or the person making the claim decision is the same person or organization as paying the claim. That's an inherent conflict of interest. And it works best with self-insured plans or where a third-party administrator gets an employer to authorize what is paid. But I've used this as well in the past, and it could possibly be be of some use in influencing a decision maker. And then if there's actually going to be a lawsuit, you could possibly get additional damages for breach of fiduciary duty as a result of the conflict of interest. Number 7 has to do with UCR, which we alluded to earlier. This is a big battleground for out-of-network and non-contracted claims. Again, if you have a contract, it's pretty specific what the healthcare provider is supposed to get paid. So there shouldn't be as much of an issue as to what is a usual, customary, and reasonable charge. But generally, it's what the providers usually charge and what others in the area and the same specialty charge. And the providers who charge the same amounts have to have the same training, qualifications, and experience of the one that's at issue. And then, at least out here, there's a provision in the California Health and Safety Code that looks at the nature of services provided. And then in subparagraph, for the last bullet there's a statement that says fair health is biased and inaccurate. So fair health was a result of litigation over the former organization that was used to create benchmarks of what's the usual customary charge. And that was originally set up by United Health, so it was deemed to be biased towards the health plans. Now, theoretically, it's not as biased. It's a different organization. But you could challenge their data based on the fact that they may be using inaccurate data. For example, if they're using Medicare claims versus private healthcare claims, and they may be using different geographic areas or different specialties. So you could challenge the fair health data as being biased and inaccurate if you got to that point. Well, let me just digress very quickly and read to you, excuse me, Section 1300.71A3B of the California Health and Safety Code, which actually specifically spells out what the law in California is on usual, customary, and reasonable charges for non-contracted providers. It says that it is healthcare services rendered based on statistically credible information that is updated at least annually and takes into consideration the following: the provider's training, qualifications, and length of time in practice, the nature of the services provided, the fees usually charged by the provider, the prevailing provider rates charged in the general geographic area in which the services were rendered, other aspects of the economics of the medical provider's practice that are relevant, and any unusual circumstances in the case. So it's a 6-part test. And as I say, there's been quite a bit of litigation in this area. There was a case on this statute, or rather this, the statute just about a year and a half ago, called Children's Hospital versus Blue Cross, which actually went to jury trial and then it was appealed. That's at 226 Cal App 4th 1260, a 2014 case. And in that case, the jury found that it was a hospital, a children's hospital of Central California that was suing Blue Cross. And the hospital wanted to get paid what it thought was its reasonable charge. Blue Cross disputed it, and the jury found that what was reasonable and customary were the hospital's full bill charges. So they were very, very happy with that. Blue Cross actually appealed the case, and the appellate court found differently. They said that the hospital has the burden to show from a market standpoint whether their charges are reasonable and customary. So it's not just what they charge, it's the market value that's ascertainable from data in the market that is the key thing. So it put the burden on the hospital to establish that its own charges were in fact usual and customary and reasonable based on the marketplace. The next slide has to do with ERISA or insurance code violations. There are laws in every state, I believe, governing insurance claims and insurance company settlement or claim settlement practices. Those are helpful because in the event of an appeal or litigation, you can use those as a basis not only to threaten to go to the regulators, but to use it as a benchmark for what the proper claims practices are. In the federal area, again, those are found at 29 CFR 2560.503-1, and then in California, they have the Claims Settlement Practices Acts for both HMOs and for insurance companies. The HMO one is found at 28 CCR 1371. And let me just briefly digress and read to you some of the unfair claims practices that the law has put forth for HMOs. The imposition of a claims filing deadline that is less than 90 days for contracted providers and 180 days for non-contracted providers. Requesting reimbursement of an overpayment of a claim more than 365 days after the date of payment. The failure to acknowledge receipt of the claim in writing. The failure to provide a provider with an accurate and clear explanation of the specific reasons for denying, adjusting, or contesting a claim. And I'm just skipping over them. There's at least 17 of them. The failure to reimburse at least 95% of complete claims with the correct payment, including the automatic payment of interest. Many states do require interest and penalties if the claim is late. The failure to contest or deny a claim or a portion thereof within the required time frames and so forth. So these are helpful tools when challenging a denial of a claim. And you should look at the state law and as well as the federal law if it applies before you do so. There's quite a bit of litigation in this area as well. The next item has to do request all relevant documents. And this is a very, very powerful tool. Most state and federal laws do require that the insurance company provide the documents that they relied on in making their benefit decision. Sometimes I request a claims manual if that was required, if that was used in the benefit decision. If there's been a reviewer on a medical necessity challenge, definitely get all the papers that the reviewer has relied on. And then once you get all those documents, now you're better off to challenge the reasonableness of the denials, or if you're in a bad faith case, you can use that as well. The federal law is very helpful in this area. Let me just read you the section of the ERISA regulation I cited on getting documents. This is what the health plan has to provide. They have to provide every claimant with a statement that they are entitled to receive upon request and free of charge reasonable access to and copies of all documents, records, and other information relevant to the claimant's claim for benefits. Whether a document, record, or other information is relevant to a claim for benefits shall be determined by the following section. And the following section is very broad. It says, a document, record, or other information shall be considered relevant to a claimant's claim if such document, record, or other information was relied upon in making the benefit decision, or was submitted, considered, or generated in the course of making the benefit decision without regard to whether such document, record, or other information was relied upon. So as long as they considered it or generated it, you're entitled to get it, at least under the federal regulations. And certainly if they relied on it. In addition, under the federal regulations, you can get any policy or guidance that somehow affected the benefit decision. So if the plan has some kind of a policy or claims manual or something of that sort, you're entitled to that as well. The last item on how to get paid has to do with bad faith. Bad faith is a tort action, whereas most insurance claims are all going to be, or disputes will be, contract actions. And it doesn't apply if there's an employment-based benefit, which, as I mentioned at the beginning, it covers pretty much most healthcare benefits are derived through the employment context. It would apply to individual policies, some government policies, such as for teachers' unions or that type of thing, where ERISA does not apply, and it may apply to Obamacare, which is basically an individual plan, although there may be some immunities there. But the nice thing about bad faith is you can get extra contractual damages, including possibly attorney's fees and punitive damages. But you must show that there's no legitimate basis for the denial, and that's why getting those documents would be very, very helpful. And again, it's not available where there's ERISA preemption. But the duty of good faith and fair dealing, which is what we're talking about here, that's implied in every insurance contract. So unless ERISA applies, you should consider a bad faith argument. All right, well, I think we're ready for the next questions.
And could all the attendees please type the passcode into the Q&A once again? Our first question is, in ERISA cases, if the initial appeal is denied, are you entitled to multiple appeals if you provide new information with the subsequent appeal request? Do multiple appeals toll the SOL?
Okay, the first part of the question is yes, but you have to look again at the operative document, the plan document. That will spell how many appeals you can have, but I've seen some with at least 2. But you have to look at each plan. They're each different. It does not toll the SOL in my experience.
Are insurance companies more likely to deny claims up front or pay claims but then recoup following an after-the-fact audit?
The most popular ways are just deny up front. For providers that they suspect have committed fraud and abuse, or they're just getting too expensive for them, they may well do an audit retroactively. But no, they're based on how many reserves they have, and they watch every penny. So they will try to deny the claim up front to the extent they can.
If an out-of-network doctor was initially denied as an out-of-network and subsequently paid the amount approved as an in-network after an appeal, how is usual and customary amount determined? The doctor was paid but wants the balance from the patient, although the EOB says they're not responsible.
Well, I'm sorry, can you read that one again, Emily?
If an out-of-network doctor was initially denied as an out-of-network and subsequently paid the amount approved as an in-network after an appeal, how is the usual and customary amount determined? If the doctor was paid but wants the balance from the patient, although the EOB says they're not responsible.
Okay, that's an interesting one. Unfortunately, once the doctor or the provider has signed the contract, that would govern what they're going to get paid. That would have a specific amount in there. If it's just usual, customary, and reasonable, if it's like an open-ended contract, then the provider can charge their normal bill charges. But it sounds like in that case, they went inside probably to cover for the claim that was denied when they were out of network. If it didn't do that, then the provider can continue to charge the out-of-network. The question is whether he can, or he or she can balance bill. And if the patient is part of that group, the health plan, or whatever it is that the provider is contracted with, then I would say probably not balance bill. That they probably cannot balance bill, and that was the reason that one of the reasons the health plan wanted them to sign, and one of the things he or she agreed to when they did sign.
Okay, what are the considerations and benefits of pursuing claims in federal court versus state court when the option exists?
Well, I would generally prefer state court over federal court unless ERISA applies or some other federal law. If there's going to be a jury, now most ERISA cases, or in fact all ERISA cases, are non-jury trials. But at least in federal court, you have to have a unanimous jury, which is not good. If you can be in state court, I think that's a better way to do it. Even though it takes a little longer, the attorneys are a little bit more in control than federal judges. And frankly, you can sue in state court even if you have an ERISA claim. There's concurrent jurisdiction.
Could you please clarify Section 8, threat of fraud and abuse, and how it leads to delays? Are you referring to claims of fraud against the insurance company or by the insurance company against the insured?
Yeah, I'm referring to the latter, by the insurance company against the insured. As I said, the insurance companies do get hit with a lot of fraud, so they're very sensitive to that, and they have computer algorithms and all that look for that. So what they will do is they will, if they do allege that, they will oftentimes send the whole claim and all future claims from that provider to a special unit called usually an SIU, Special Investigative Unit. And then and that will delay it because now they're going to say, well, we need a lot of time to investigate this. And that takes them outside of the state laws or the federal laws governing the deadlines they have to pay a claim.
Okay, those are all the questions we have for now. There are some additional questions, so if you don't mind, Bob, we could send them over to you to get responded back to the attendees, if that's okay.
Sure, that's fine.
Okay. Okay. In addition to being your best source for testifying and consulting experts, TASA also offers e-discovery and forensic solutions, free interactive webinars, cybersecurity services, day-in-the-life videos, and research reports on expert witnesses, such as the Challenge History Report 2.0, the Professional Sanction Search, and Expert Profile 360. I want to take this opportunity to thank everyone for attending, and most especially Robert Amador for his time and effort in creating this presentation. If you would like to speak with Mr. Amador, if you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA at 1-800-523-2319. Tom Masucci, who has been sitting in on today's webinar, will be following up with you with regard to your feedback on today's presentation. Thank you again and have a great day, everyone. This concludes our program for today.